All right, good morning. We're on the record in the 89th District Court for the County of Sheboygan. We're here in the matter of contempt of Beth Bridgman. It was committed and filed under the case of People v. Seth Flores, filed 23-0868SD. Counsel, you want to state your appearance for the record, please?
Melissa Goodrich, Wayne County Prosecutor.
All right, Ms. Bridgman is not present in the courtroom. Have we confirmed she's not out in the hallway?
Confirmed, not in the hallway.
Okay, she's not out in the hallway. Ms. Bridgman was, the court issued a order to show cause why she should not be held in contempt for the unauthorized practice of law and also preventing Defendant Flores from meeting with his attorney before his arraignment. I do see in the file a proof of service that she has been served with that, and in fact also in the file where Ms. Bridgman has...
This is Beth Bridgman, and instead of showing up for her contempt hearing, she literally cut up the judge's order and handed it back like a ransom note. The prosecutors are not even playing around here. Straight to a bench warrant. No bond. That's a record-setting speed run from summons to arrest.
Appearing as arraignment attorney on behalf of Beth Bridgman.
Although I will represent myself.
Yes,
okay.
we'll get to that.
I would like to say I'm here on special appearance. No, I think I have some rights here. I don't know.
What does special appearance mean to you?
It means in a common law that I'm a living soul. I am not the straw man of the all caps.
And you'll have an opportunity at a later time. Please just take a seat.
I've never seen those opportunities come back around. Thank you. Okay.
We'll get to that.
It's classic sovereign citizen lingo. Special appearance, living soul, strawman. It's all code for I don't recognize your court's authority. And then she adds a plot twist. A state trooper supposedly told her the order was invalid. Folks, this is how sovereign defense goes. If they think they found a loophole, they're sprinting through it, no matter how imaginative.
Actually, so thank you very much, because I will represent myself.
Okay. So you're telling me things in defense of the contempt citations, and you'll definitely have an opportunity to present any.
No, because you already.
Hang on, Mr. Villanueva, please stop. I don't want to have this be an argument between you and Ms. Bridgman.
I just like to state that.
Well, I think we need to back it up.
Pleading not guilty to both of those, and that she would like to request a hearing, that she would like to represent herself at that future hearing.
No, but all of my rights were strongly impinged upon for even when I never failed to appear.
Okay, we're going to have a hearing where you.
She was working.
Okay, you're going to get your.
Mr. Villanueva,
no,
I'm
this
directing you
is.
to stop
Thank you.
arguing with Ms. Bridgman.
Okay.
I mean, it's a pretty serious thing to have to spend the night in jail, to be brought in handcuffs and everything else. When I was not being belligerent in that regard, she told me that it was not an authorized.
She's playing a dangerous game here, asking the judge for statutes and refusing to acknowledge the charges. In a normal legal setting, this might be a misunderstanding. A contempt case is a fast track to a jail cell. And notice she's still trying to control the conversation, not answer the actual questions.
Context of everything today, Judge Gothier.
It's really quite simple. When you have an order to show up for court and you turn in a cut up piece of paper of it to say you're refusing to attend, that this is what happens next. That's pretty simple.
Oh, did that offend you?
No, it did not offend me. It was a contempt of court.
Oh no. She did not just pull the I have more degrees than you card on a sitting judge. You can practically hear the oxygen leave the room. That's not legal advice. That's asking for the maximum sentence with extra sass.
On the phone with the trooper. And then people told me after I went up for Christmas that there was maybe a bench warrant, that you had issued a bench warrant. But everybody looked for it online at VineLink and couldn't find any bench warrant. So I was not trying to. I thought that trooper had told you what she told me, that I wasn't on bond, so I couldn't have a show cause.
Okay, well, that's all going to be sorted out at the hearing. Okay, we don't have to sort all that out today.
Well, that's a lot of overnight in being arrested downtown and everything for a misunderstanding that I would like to.
Mr. Richmond, I mean,
okay, I get it, Judge Gothier. I know what happened.
You're not fooling me. I've got the show cause that you apparently cut up into little strips and wrote.
Yeah, but I brought it at 9 o'clock because do you know that that's actually a common law practice? And there are courts that recognize common law because sovereign people and people who take an oath of office.
Here is sovereign citizen logic in its purest form, cutting up a court order and calling it a legitimate legal process. And to be fair, she's not wrong that some fringe courts have entertained these ideas. But this isn't one of those courts, and that's the problem.
Whether you should be released on your own recognizance or whether you should be required to post a bond before the next hearing. So I'm going to hear first from the prosecutor and then from you on that question. Ms. Miller?
Your Honor, I would object to a PR bond in this case first because of her failure to appear on December 20th. She had notice of that hearing date as she dropped off the show cause to the court that had the date on it. Further, an underlying case that this was initially filed, she encouraged someone to not appear for their court date or to leave the court before they were arraigned. So I do have a concern about her appearance at the next trial, the next date.
All right, Ms. Bridgman, anything you want to tell me with regard to whether I should allow you to be released on your own recognizance before that hearing, or whether...
I showed up at 9 a.m., Your Honor, and anybody could have called me if they didn't understand that. I filed a similar document in Mackinac County and they accepted it. Common law is a very acceptable kind of a standard if you know it and you know what you're doing. So maybe there'll be a chance that I can present some of these other avenues, because how does my country tell me to take an oath of office to defend the Constitution, but then I'm held to only codes and statutes of the Michigan legislative body, governor, and perhaps Supreme Court?
And here's the moment, the judge's final move. The prosecutor says she's a no-show risk. Beth challenges the entire legal system, and the judge answers with a $10,000 cash bond. That's the court's way of saying you may be a living soul, but you're also staying put.